federal law that's called the Controlled Substance Act, and it sorts different drugs and substances into different schedules or categories. The ADA often intersects with drug and alcohol use and raises some questions for employers of what they do when an employee is either under the influence or they are a recovering addict. Pre-employment testing. And so, this is entirely optional for employers. This is prior to hire. And so that's important when you do give an employment offer. If you intend to do pre-employment testing, you always make it a conditional offer. So that gives you the space and the ability to go conduct background checks.
Welcome and thank you all for joining us for another Justia webinar. My name is Nina and I'll be the moderator for today. Now, without further ado, let me introduce our speaker for today, Jackie Staple. Jackie Staple, a labor and employment attorney based in Jackson Walker's Houston office, focuses on advising and counseling companies on employment law compliance and handling labor and employment transactional matters. Jackie has a depth of experience drafting various employment, separation and release, and restrictive covenant agreements, as well as conducting due diligence of employment considerations in equity and asset transactions as a member of the mergers and acquisitions deal teams. The webinar presentation that you're about to watch will be approximately 1 hour, and Jackie will be taking questions at the end of the presentation with time permitting from the audience. If you have questions that you would like to submit to her, you can always do so by clicking the Q&A button in the control panel at the bottom of your screen and sending them in there. Now let's turn to Jackie to discuss Up in Smoke, drug testing and marijuana in today's workplace.
Well, good afternoon, or I guess good morning, everyone, depending where you are. Thank you for that great introduction. Again, my name's Jackie Staple. And today I'm here to talk with you about what I've called Up in Smoke, drug testing and marijuana in today's workplace. Again, as mentioned, I'm a partner at Jackson Walker, and I practice labor and employment law exclusively. And I do a lot of counseling and advice, as well as, if need be, represent clients before agencies and go to court and litigate as well. But several times a year, issues come up with drug testing in the workplace, and I help counsel clients through those issues. And it seems like it's becoming more and more prevalent, especially with a lot of confusion in the law and how to comply with marijuana and how various federal and state laws currently interact. So today, our agenda will touch on those issues, and we will focus heavily on marijuana specifically, but we'll also talk a little more broadly about other types of drugs and how drugs and marijuana impact the workplace and present unique compliance challenges for employers. The first part of the presentation, we'll talk about some fun facts. So just talking about marijuana, prevalence of use, and hopefully some things maybe you did or didn't know. The second part, we'll talk about what is it. So it'll look at various categories or types of illicit drugs and show what sorts of characteristics those might present in employees who are under the influence or perhaps have addiction to those drugs. And this will be important, as I'll explain, to help managers recognize these signs so that they can properly address compliance issues in the workplace and safety concerns. The third part, we'll talk about marijuana laws today. So as I mentioned, that federal and state intersection and, where we're at and how things have developed over the last decade or so. The fourth section, I'll touch on the Americans with Disabilities Act, and there are also many equivalent state laws as well, and how those disability accommodation laws intersect with marijuana and other drug use. And then finally, we'll wrap up by talking about drug testing generally. So some tips, tricks, and best practices for compliance. So our first section, let's talk about some fun facts. So recent statistics show at least 48% of high school seniors have used marijuana at least once in their lifetime. And chances are this might even be higher because keep in mind, this is self-reporting. These statistics come from the National Drug Intelligence Center. And they also come from the University of Michigan's Monitoring Future Survey. 22% of high school seniors have used marijuana in at least once in the last month. And this could be any form of marijuana. So this could be smoking a blunt. This could be, THC within gummies. It could be a variety of types of use. And some of these statistics today we'll talk about actually come from the National Survey on Drug Use and Health. And this survey, it fascinates me. It's conducted usually annually by SAMHSA, which is the Substance Abuse and Mental Health Administration. That is a part of the Department of Health and Human Services. So it's part of our federal agencies. And they actually send out surveys to about 17,000 households. And the way that they do it, I guess, is coming up with census data and trying to evenly distribute these surveys across various demographics across the census data that they have. So they're trying to get a really good sampling of what is out there. And so it's always been interesting to me that people would, voluntarily respond to a survey like that because it asks about things um, from mental health, alcohol, and nicotine use all the way to illicit drug use. And apparently the illicit drug use questions are handled, as you may imagine, in a very sensitive way to try to get as many voluntary responses as possible. So those questions are run through the computer and not necessarily with the interviewer. And the interviewer is blocked from seeing those answers. So draw your own conclusions on the reliability of that data, but there are measures in place to protect those answers and not tie those answers to a particular person or their address. So, continuing on to talk about some fun facts of marijuana specifically, there are all sorts of marijuana street terms, and I'm sure you've heard them, whether it's in various pop culture references, songs, movies, or whether you've heard the lingo on the streets, so to speak. But it is important for employers and managers to have some awareness of street terms for marijuana as well as other drugs, because if you have a zero tolerance workplace policy for drugs and alcohol, or you just want to keep drugs or people under the influence out of the workplace, if employees are talking, they might use some of this slang to refer to drugs or other substances versus just say, oh yeah, I have marijuana in my bag in the locker room. They're not going to say things like that. So these are some of the common ones that I've heard, some that, I just picked out of a list to demonstrate kind of the breadth of nicknames just for marijuana. This is not even covering other types of drugs. Um, then let's talk briefly about just marijuana generally and what is it. So there are many different strains of cannabis, which is the marijuana plant. And each plant has chemicals in it and different compounds called cannabinoids. And each plant also has different what are called terpenes. So that's the smaller the taste of that particular strain or plant. And so there are several primary strains, although there are many, many strains because marijuana can grow across the world. And so some of the common ones are cannabis indica. So that's one of the primary strains. And that's known for its therapeutic potential to help out with anxiety and chronic stress and other related medical conditions. It's generally associated with more of a calming and relaxing effect. And you can identify it by its broader leaves and wider leaves. Then we have cannabis sativa, and that's another one of the prominent strains. And that one's more known for an energetic or boosting effect. So a little bit different feeling when you use it. It's also used to treat medically some different types of disorders. So it's used more for chronic pain, MS, migraines. So there have been different types of conditions that, those who prescribe to marijuana being medically significant believe that the different strains will treat different things. And then there are some other lesser known strains. There's Cannabis ruderalis. That's one of the lesser known strains, and it really grows in harsh climates in Eastern Europe and Russia. But why it's known is because it doesn't need any particular light conditions to flower and bud. And so it's been very useful to some in creating hybrid strains. And obviously, hybrid are a mix of different strains, and so they can offer different effects. What's interesting about marijuana is the economic impact that it's had ever since recreational marijuana started becoming legalized in some states at the state level. And so, to be clear, as we'll talk about in detail, currently marijuana is still classified and is a legal drug as a Schedule I substance under federal law. But some states have legalized it for certain purposes. Some places, those purposes are more limited. In some, there is a broader array of ways you could use marijuana legally. And so some of the broader states are Colorado, as you'll see on your screen. Colorado and Washington were the first state to legalize recreational use of marijuana, and that was back in 2012. So we're going on, 13, 14 years in those state data that we have in seeing the economic impact of doing that. And so state of Colorado Department of Revenue has put out this infographic on different taxes and fees that the state has been able to take in. And you can visually see just the amazing economic impact it's had for that state. It's a 20 billion plus industry each year and growing. As of the date that I collected data, there were over 15,000 dispensaries in the United States, averaging about 6 jobs per dispensary. So it's an economic job creator. And then also, when you look at it, not only has it been a tax generator for some states like Colorado, but there is also potential tax savings. And so when you look at our federal government, over $3.5 billion are spent each year on enforcing, drug offenses related to marijuana. And so you think of it from a savings perspective, if that wasn't the case and marijuana was legalized at the federal level, the tax dollars that would be saved. And that's an argument that proponents of legalizing marijuana at the federal level will often present. So moving to our next topic today, what is it? So as I mentioned, when you're talking about employers, employees, usually your frontline folks who are enforcing your policies are your managers. And these could be lower level or middle managers. These could be your executives, but the managers are the ones who are interacting with other employees and supervising them. And they're on the front line, so to speak, of recognizing when an employee may have an issue with drug or alcohol dependency, and when those employees, importantly, might be under the influence of a substance while they're at work. So it is important that they can recognize some common signs of individuals being under the influence. That's not to say that managers should or should be expected to become experts or even to the level of a medical expert who could identify, with certainty what is going on. But they need to know enough to say there's something off here and enough to be able to articulate those factors to support reasonable suspicion testing, which we'll talk about later today. So again, not meant to make everyone an expert, but this is to provide a general overview. So again, going back to our friends at SAMHSA and looking at data, this slide represents data from 2023, although I checked the 2024 data as well, which is the most recent year, and it is roughly the same in terms of prevalence. And so when we talk about the drugs on that survey, the most common ones aren't even, so to speak, illicit drugs. Alcohol, by far, is the most commonly used drug that SAMHSA includes on the survey by many, many multipliers. Alcohol within certain confines is legal. So that's a factor that impacts that. The second is nicotine, which as well, for certain populations, it is legal to use nicotine, especially when we talk about other types of tobacco products as well, like vaping that we have now. This is not surprising. So after those two, then you get into your illicit drugs. And what are your most common illicit drugs that are being used? So marijuana is right up there. And as we'll talk about as we continue, the legalization at the state level, as well as different dispensaries and places where you can consume THC products, is likely driving an increase in this. Then you go to psychotherapeutics and opioids. Next would be stimulants, and then hallucinogens, tranquilizers, or sedatives. So we'll talk about each of those and break those down into what are they and what sort of things do they do to the body. So first, going back to marijuana, again, we're talking about the cannabis plant. And within plants, there can be over 480 chemical compounds within a plant. And so we're really talking about, again, the THC, which is the tetracannabinol. That is the chemical that has the intoxicating effects within marijuana. There are plenty of other chemical compounds, but this is the one that everybody knows about and talks about. The cannabis itself is really referring to the dried leaves, stems, and buds and other parts of the marijuana plant. And oftentimes, people will say the higher quality marijuana will have more of the leaves and the buds, and then kind of lower quality will also incorporate some of the stems and some other parts of the marijuana. But the point is, we're really talking about the THC. That's the psychoactive part. And what the THC can do is cause changes in mood and thoughts and really perception of reality or perception of your environment. Importantly, for in the workplace, if you are keeping an eye out for drug paraphernalia, as you may know, marijuana can be consumed in multiple ways. So you can smoke it from a pipe. Often these are blown glass pipes. You can roll it in a cigar shape and smoke it as a blunt. You can also consume it in gummies. There's always the reference to pop brownies. And so it can be within a variety of other substances, and it can also be within different forms. And so the long-term use of marijuana has been shown to actually mute the brain's response to dopamine, and that's how the THC works. And so dopamine is our body's reward hormone. And so that is what it is doing. It's actually changing the body's response to dopamine. So what can long-term effects or effects of long-term use of marijuana look like? So all the things you see on the slide here: memory problems, learning problems, slow reactions, distorted perceptions, less coordination. It affects the brain as well as other parts of the body. And so you can see why this would be important when you're talking about employees of your company. If they are long-term marijuana users, this could affect things like their performance. You might see performance declines as a result. Some of the outward signs that someone might be under the influence include dizziness, nausea, a flushed face, dry mouth, tremors, or just extreme personality changes like extreme happiness, extreme elation, extreme relaxation. And then, as most of us have heard, it could be a case of the munchies, so an increased appetite. Moving on to the next common category, we have psychotherapeutics and opioids. And so these come from the poppy plant, very pretty plant that can potentially have very devastating effects. Opioids have been used for quite a long time for pain relief. Today, they can be natural or they can be synthetic. And opioids include the drugs you see up on the slide: fentanyl, oxycodone, hydrocodone, codeine, morphine, and heroin. And so some of those are used even in anesthesia and pain relief for legitimate medical purposes. And that is what has caused, in recent years, the opioid epidemic, which I'm sure you've all heard of and followed in the news, and it's still ongoing. The opioid epidemic, it essentially started when doctors or medical professionals and pharmacies, as alleged in many of the lawsuits, were prescribing or overprescribing various forms of opioid medications to patients. And in some cases, it was communicated that they would not cause addiction, and they actually did cause addictive effects. Um, in 2024 alone, over 80,000 people died as a result of the opioid epidemic. And when you look at overall drug overdoses in the United States, it's estimated about pretty close to 3/4 of those involve some sort of opioid. One of them that is currently very prevalent right now and is kind of the next wave of the opioid epidemic is fentanyl. And so that is a synthetic opioid, meaning it's created in a lab. It's not one of the natural kinds. And a few little grains of fentanyl, so think a size of a grain of salt, can be fatal. If anyone's ever had surgery and utilized morphine as an anesthetic or a pain reliever, it's 100 times stronger than morphine. So you can imagine that. And it's often mixed in with other drugs and can't be visually detected or detected by the other senses, like by taste. So what do opioids do to individuals who are under the influence? Well, they can cause extreme happiness, drowsiness. So think, pain relief, nausea, confusion, constipation, sedation, and breathing problems into unconsciousness. So some of these symptoms might appear in employees who could be under the influence. And up on the slide, there's an image of a fentanyl lollipop. And so if you've ever heard that term, and I had to look this up, it's not necessarily an actual lollipop. It looks like what's up on your screen. And so if you're talking about, drugs in your workplace, it's also important to know, as mentioned with marijuana, that can be used in many forms. What are the forms that drugs can be used in, so that you can recognize what this might be if it falls out of someone's bag at work or you see it somewhere at work. The next category of substances we'll talk about are stimulants. And so there are many legal stimulants, and then there are the illicit illegal stimulants. And so the most common stimulant I just had this morning is a cup of coffee. So it has caffeine in it. Caffeine is a very common and accepted stimulant that many of us rely upon. What stimulants do is they increase central nervous system activity. And so when we talk about the illicit types, we're talking about amphetamines, meth or methamphetamine, cocaine or coke. So think those types of drugs. It's going to cause chemically in the body increased activity at different receptors that impact your adrenaline. And so it's going to cause increased energy, euphoria, increased libido, at least in short term, increased cognition. The thing is, when we're talking about impact on employees in the workplace, there are many stimulants, as mentioned, that are legal. So there are prescription medications, think Adderall or Ritalin. Those are commonly used to treat disorders like ADHD or narcolepsy. Those can be prescription medications that are legitimately prescribed to an employee in your workplace to help them combat a medical condition. But if abused or in whatever dosage they're taking, it may cause impacts to them that could cause a safety issue for the workplace. And a fun statistic for you, back in 2023, almost 4 million people reported misusing prescription stimulants. And so it's not just stimulants, it's any prescription medicine can get pretty tricky when you're talking about workplace accommodations versus workplace safety. So stimulants can cause things like headaches, sweating, pounding heart, chest pain, nosebleeds, weight loss, because you think you're speeding up the body. And so some of those effects you feel even with drinking a cup of coffee can be amplified with other prescription or illicit stimulants. On the flip side, they can cause hyperfocus and alertness. And so they're often abused when, someone has to complete a big project or you're under a time crunch. There are people who rely upon stimulants to help them get through that. The long-term effects or effects, if taken too much, can divert into some very negative effects. Finally, we have hallucinogens. And so think back to your, stereotypical 1970s psychedelic. You're at a room with tie-dye lava lamps, and people are partaking in shrooms. Those are your hallucinogens. And these have been around for, centuries and used by various cultures across the world. So think even peyote with certain Native American tribes, that has, classically been utilized, all the way to other harder drugs like LSD and PCP and ecstasy. So again, these can be natural or synthetic, and they really just change your awareness of your surroundings and change your perceptions of the environment around there. The way that they do that chemically is they're interfering with serotonin. And that's one of our chemicals that helps with sleep, hunger, mood, kind of our body cycles and regulating our body's internal workings. So that's what it's impacting. They also interfere with glutamate, and that controls emotions, pain perception, learning, and memory. So again, continuing on the slide, here are some of the effects. So again, your perception of the environment will just change. You will lose touch with certain aspects of reality. You could even hallucinate. You could have agitation, seizures. And then some of the physical signs that would be helpful for managers or others to look out for in employees: dilated pupils. And that's kind of an outward sign that can indicate a variety of things that are totally fine and safe and not unlawful, or could indicate some sort of drug use or being under the influence. And the same is true with a lot of these outward signs. And that's why it's really important to handle any reasonable suspicion testing in a careful way, which we'll talk about in just a little bit. And then we've got tranquilizers or sedatives. And so these are commonly known as your benzos or benzodiazepines. And so we're talking about substances and drugs that cause sedation or put you into a state of hypnosis. These are really your muscle relaxants that calm the central nervous system. And these are also, part of some prescription medications, and they're very easily abused. So at least 6 million people recently have reported abuse of tranquilizers and sedatives. And they really can start to cause tolerance and dependence. So they're going to slow the brain, and the nervous system can be used to treat a variety of disorders, from anxiety and depression to insomnia. So commonly utilized, things like Valium and Xanax are some of the ones that you may have heard of. And so again, this just summarizes some of the effects that you might see outwardly. And really, it's a lot of slowing and relaxation you'll see. So next, let's move to topic number 3, which talks about marijuana laws. So where were we? Where have we come from, and where are we now currently? So let's talk about federal law. And so from a very, very high level, I know I'm talking to a lot of lawyers. So this, is background information, but there may be individuals who don't have legal background or training. So in the United States, we have our federal government. We have our 3 branches of government. So we have Congress that makes laws, the executive branch enforces the laws, judicial branch interprets the laws. We also fall under a system of federalism, where the federal government, has a limited jurisdiction of what it's in charge of, and then many things are left to each individual state, often called police powers, things that affect public policy and public safety, with, of course, exceptions. So we have federal law that's called the Controlled Substance Act, and it sorts different drugs and substances into different schedules or categories. And each of those categories has a different meaning of what the drug does, or, its use, and also its dependency and how likely it is to cause dependency or other harms. Controlled Substances Act falls under the Department of Justice for enforcement. And currently, marijuana is classified as a Schedule 1 drug. So under the Controlled Substances Act, or CSA, that means a drug with no currently accepted medical use and a high potential for abuse. So we are still there. There's been a lot of chatter, and I constantly hear people saying, "Oh, well, marijuana is legal now." Where it is not at the federal level, and there's a lot of confusion out there because things have gone back and forth so much. So, uh, way back in 2009, think back then, we're under the Obama administration at that point. That administration sent a memorandum, the Cole Memorandum, to federal prosecutors. And it essentially encouraged them not to prosecute people who distributed cannabis for medical purposes in accordance with state law. And that was because many states had enacted um, quote unquote medical marijuana laws that allowed certain card holders or individuals who were prescribed marijuana or that it would be helpful for their treatment to utilize a certain amount, have it in their system, and or potentially grow plants in their home, because people were more and more seeing marijuana for medical reasons and purposes, and it was becoming more widely accepted that this was a substance that could assist with many different disorders or conditions, such as epilepsy or MS. So that was put in place, but federal prosecutors, they do have discretion in terms of what they want to spend their time and resources on and prosecute. So it was really an encouragement. Then we get to 2013. And so at that point, the Department of Justice, or DOJ, announced an update to its enforcement policy. And this was really in response to, as I mentioned, Colorado and Washington legalizing certain recreational use of marijuana. And DOJ essentially said, look, we understand what you did, states. We're really not saying one way or the other. Do we condone it? Do we not? But we trust you, states, that you'll put in strong state level enforcement efforts. And so we're going to just defer the right to challenge those laws at this time. But, in the future, if we think it's necessary, we're going to reserve the right to challenge these laws. Then a few more years go by and we get to 2018. And there was a marijuana enforcement memorandum implemented, and it rescinded the Cole Memorandum. And it basically said to federal prosecutors, decide what you want to do with federal cannabis law. Decide how much time and resources you want to spend on enforcing it, and kind of allowed a lot more discretion. It instructed them to weigh all considerations, including the AG, or Attorney General's, law enforcement priorities, the seriousness of the crime, the deterrent effect on criminal prosecution, and the cumulative impact of particular crimes on a particular community. So that's where we come from. It's been a lot of back and forth. It's been a lot of, okay, we're just going to be hands off. We're not going to do anything official. But we're also just going to kind of, in some ways, a wait and see approach. So essentially that's where we are. Then we get to some more recent developments within Congress, which again is the legislative branch. So some of you may have been following what's been called the MORE Act. And the MORE Act, or its equivalent, is not something that's new. It's relatively new. So back in 2020, and then again in 2022, the U.S. House of Representatives within Congress voted to pass the MORE Act. And the acts would have essentially imposed a federal tax on marijuana, on cannabis and cannabis products, and decriminalize it nationwide. So it would remove it from that CSA, Controlled Substance Act, list. So it wouldn't be moving it onto a different schedule. There have been proposals to just totally remove it. Both times the House said, cool, let's go forward. And the Senate, it just died in the Senate. Either there weren't committee votes or hearings necessary, and so it just died. It's back, and so right now, again, it's just sitting there. The current version would impose a 5% tax on these products, and would remove it from the CSA schedules. So essentially, it would legalize it at a federal level and then allow taxation of it. So it would be a revenue stream for the federal government. Then also in latest news, President Donald Trump issued an executive order, and it has a big long name, Increasing Medical Marijuana and Cannabinoid Research. And it was issued back in December of last year. And this executive order was framed as, look, marijuana might have medical impacts. We want to help support research efforts. We want to make it easier for research. And so in order to expedite that process, we're going to move it from Schedule 1 to Schedule 3 for these purposes. And what Schedule 3 is it recognizes that the substance has some medical use and it has a lower potential for abuse as compared to Schedule 1 and 2. So essentially, it's to promote research, reduce those restrictions, and also helps allow businesses to take normal tax deductions who are in the marijuana industry. So when you think about, legalizing marijuana or legalized marijuana, that's often a broad term that people use. And there's a patchwork of state laws related to marijuana. And so you have two things to think about. You have, is it legalized in certain states for recreational purposes? And then is it legalized for medical purposes, and to what extent? And so this is a nice chart that I have borrowed here, and it gives you an infographic of legal status of marijuana. And so when you're looking at the white states, those are states where marijuana use is not legal. Light green states are states where medical marijuana use of some sort, to some extent, is legalized, but recreational use is not. And then the darker green states are those where there is some degree of medical and recreational permissible marijuana use. Keep in mind, at all times, still under federal law, it is not permissible. It is not legal use. Then when we look at medical marijuana, again, there is a patchwork of what can be used for medical purposes and under what criteria or restrictions. And so the various colors on this map that I borrowed will also give you some of that information. And this is a great source, the National Conference on State Legislatures. If you ever need to know kind of a 50-state survey, or you need to look up certain states and what their law on a particular issue is, this site keeps summaries of various types of issues and has really nice graphics like this that you can refer to. So it's a source that I often turn to within employment law, because as you may know, there is also a patchwork of all employment laws for compliance purposes. So you always have to check federal law, but also state law, and then sometimes even down to the county or city or other local level. So when we talk about marijuana laws and acceptance, these are some of your least restrictive states. And so you can see some on each coast: Michigan, Illinois, Alaska. And this is just based upon states with the broadest permissible uses for medical purposes and then recreational use. And then let's talk about home cultivation laws, because that's a whole nother topic. So many states are allowing people to cultivate marijuana plants at home. And you'll see the key categories are: can you have a mature plant? Can you have an immature plant? And how many plants can you have per adult or per household? And it varies from state to state. But as you'll see, and I won't read through all of these, but they're there for your reference. You've got this list of states, and it continues on to the next slide. And so that represents about almost half of the states that are allowing some form of home cultivation. And then you're also seeing social lounges pop up. And so these are some of the states where they are most numerous or most prevalent. But any state where there's some permissible form of use, you're going to either see more of these or see these pop up. The next area of marijuana laws are anti-discrimination laws. And so within employment law, you have many laws that prohibit discrimination based upon protected characteristics, protected leaves of absence, or protected conduct. So some of the common characteristics that I am sure you've heard of is you can't discriminate against someone based on their race, sex, religion, color, national origin, and that's at the federal level. And then many states prohibit other types of discrimination. You can't discriminate based on age, based on certain qualifying disabilities, and the list goes on. Now, when you're looking at protected characteristics, not only do you have to go through those criteria, especially if you're determining how to advise the client or if you are the client, how to proceed with, for example, an employee termination or hiring an employee or not hiring them. So you have to look at it from the candidate, applicant, and the employee perspective. Now this layer layers onto that marijuana-related laws. And so there is a thought process that with drug testing, certain drugs that are in your system will be indicative of showing impairment at that time. But that marijuana stays in your system for several weeks after you have consumed it, smoked it, utilized it. And so if you're testing an individual, a candidate or an employee, they may have a positive result on a marijuana test. However, they're not necessarily under the influence at that time. And if they utilize that marijuana in a state in which it was legal, that their employment should not be impacted. An employer should not be able to make employment determinations based upon that test result. And that's what these laws are based upon. Now, each one is a little bit different, but these are some of the states on your screen where you need to start thinking about that and looking at that if you're not already, because you could run into issues if you're making employment decisions based upon marijuana on a drug test. I'm going to highlight a few locations that have these types of laws. We won't talk about every one of them, but you'll start to see some common themes. So, of course, we had to talk about California. If you practice employment law or assist in any way with employment law, you know California is what I like to call the problem child. Its laws are extremely employee protective, and they are so far protective that they are different than most other states. And so you layer that with the fact that California is an extremely populous state, you can run into a lot of compliance issues. California has a state law called the Fair Employment and Housing Act, and that is the state's anti-discrimination law, and it covers all sorts of discrimination. So it's employment discrimination, housing discrimination, other types. So protection based on all the protected characteristics we just talked about, like race, national origin, that all falls under the FEHA. And now marijuana also falls under the FEHA and has for a few years. So the law is an anti-discrimination provision for use outside of work hours. So you can't be using it during work and away from the workplace. It says that employers cannot take an adverse action based solely on a positive drug test. So if someone has a positive drug test, the key is, do you have enough other articulable facts that would demonstrate that there is impairment that is impacting the workplace? You can still enforce your penalties against active impairment at work. So this law doesn't mean that people can come to work high and cause safety concerns and perform poorly because they are high. That's not what it means. Under this law, there are certain safety, sensitive, and other types of positions that are exempted, meaning the anti-discrimination protection does not apply. And that is a common theme that you'll see in most of these laws. Another one is Montana. So kind of a similar anti-discrimination provision. So it's going to apply to use off the job, away from the workplace. But it's not going to apply when an employee is having effects on their ability to perform or they're causing a safety concern. New York's law, called the Marijuana Regulation and Taxation Act, again, says no discrimination for legal off-duty use. And so, this comes up time and again, especially in states that don't have legal use. What do you do when an employee goes to a state where there's legal use and then comes back to your state where there's not legal use? And so really, you have to also think about legal off-duty use that way. And in those circumstances, it is context dependent, but usually it's still okay to proceed with enforcing your zero tolerance policy and following your policy on no tolerance for a positive result if you're in a state that doesn't protect just that positive result. In New York, though, it's even a step further. You're actually not permitted to drug test for marijuana as a matter of course. But you can still say in your workplace, we don't tolerate being under the influence or using it at work. You can still conduct reasonable suspicion testing. So you have to have those articulable facts that someone is impaired. There are, of course, exceptions for compliance with federal regulations and then safety-sensitive positions. Our next location is Pittsburgh, Pennsylvania, and I like to point this out because it again illustrates what we face in employment law, where you always have to start with federal, look at state law, and now you really even have to drill down to the local level. So Pittsburgh, Pennsylvania, as a city, decided to enact one of these similar anti-discrimination laws for medical marijuana users. So again, you do not have to permit employees to be using at work. You can discipline for being under the influence, for causing safety issues, for not performing. You can still conduct your reasonable suspicion testing, your post-accident testing, and this law does have one of those similar exceptions. What's interesting about Pittsburgh, too, is, it's more of an union territory. So typically the northern part of our country is more union heavy. So there is a specific exemption for your collective bargaining agreements. And so if drug testing is outlined in those agreements, that's accepted, and generally speaking, you can still follow that. And then Washington State. So not surprising, Washington would enact one of these laws, being one of the first two states to enable recreational marijuana use. And not much is different about this law in terms of the broad themes of these laws, with the exception that there are rules on applicant drug testing as well. So we talked about protected characteristics, and I foreshadowed that one of those is a disability, a qualifying disability. So our fourth topic is talking about the Americans with Disabilities Act, and some of these concepts will also apply to equivalent state laws. And so the ADA often intersects with drug and alcohol use and raises some questions for employers of what they do when an employee is either under the influence or they are a recovering addict. So this is some of the language from the Americans with Disabilities Act, and it contains some of the key components you want to look at. So is the person a qualified individual on the basis of a disability? And so do they have what qualifies as a disability under the law? And disability is very, very broad under the ADA. Almost anything will qualify, any medical condition that substantially limits a major life activity. A few things don't. Temporary ailments. Sometimes you'll get a case where an employee has a broken bone and they claim that they're disabled. That's really a temporary ailment, usually. things like a common cold or the flu, those really don't generally rise to disabilities unless there are other factors or other symptoms that themselves are causing disabilities. And then you have to look at, um, like I said, is it impacting a major life activity? So again, a person who's a qualified individual with a disability, they still have to meet the skills, education, experience, and other criteria for their job. They just need a reasonable accommodation to help them perform the essential functions of their job. So we're not talking about little side tasks here and here they might be asked to do, but what are the core things that their position is supposed to do? Um, Incidental job functions do not count when you're making this inquiry. There are also exceptions to when an employer has to make a reasonable accommodation, meaning some sort of alteration to the way the work is done or to the work environment. And those are undue hardship or direct threat. Undue hardship is really a factors-based inquiry. It looks at different factors of the employment situation, such as the financial resources of the employee's location, the resources of the greater company they work for, the effect on operations. And so it's going to be, a fact-based judgment call. Does this constitute undue hardship for the company or not? And it's a fairly difficult standard to show. Not any little inconvenience is going to rise to undue hardship. And then direct threat is not often used, but it does have some relevance here where an employee would cause either themselves or others essentially pose a direct threat of harm to them in the workplace due to their disabling condition. And this can sometimes come up with mental health conditions when, individuals may exhibit behavior that impacts other safety in the workplace. So again, going back to definition of a disability, we're going to be looking at, does it limit a major life activity? And similar to the definition of disability, this is very, very, very broad. So in order to qualify for protection under the ADA, your disability actually has to cause you some difficulty and major difficulty in things like walking, talking, seeing, learning, even think of cancers. That would be the life activity of normal cell growth. You can also present a claim if you've had a history of that disability and your employer knows about it, or if you're associated with someone with a disability. And then to show a claim, you'll have to show as an employee that you're subject to an adverse employment action because of your physical or mental impairment, or in a failure to accommodate situation, and that you requested a reasonable accommodation and the employer either didn't provide that or failed to go through what's called the interactive process to find an effective, reasonable accommodation for you to be able to work. So when we talk about the ADA and marijuana, how they intersect, the biggest misconception that I hear is you don't have a requirement to accommodate marijuana in the workplace, generally speaking, under the ADA. It is an illicit drug. ADA is a federal law. You don't have to accommodate it. That is in direct tension with state laws, especially these newer, more recent state laws that are anti-discrimination provisions. Just conceptually, and then actually implementing these laws, there's tension there, and sometimes you have to make a judgment call. The ADA says absolutely yes, you can still maintain your drug-free workplace policies. You do not have to give accommodations to current illegal drug use. And so sometimes, the question comes up, okay, I have this employee and they showed up to work and they are clearly under the influence of something. Do I have to start engaging in an interactive process because I now know that they're a drug user? And so it might be a disability, and do I have to accommodate them? The answer is no. You don't need to. First off, don't let them start working if they show up to work and they are impaired. Remove them from the work environment. And second, Under the ADA, that does not trigger a duty to accommodate them. But what the ADA does protect is rehabilitation. And so if an employee comes to you as an employer and says, I was addicted to marijuana or X drug, and I've decided that I'm going to undergo rehabilitation, and I'd like a short-term leave of absence as a reasonable accommodation to do that. And I'm not a current user, not a current addict, but I need to go to rehabilitation, or they need some type of other accommodation. Maybe they've gone through rehabilitation, but they just need periodic medical appointments or check-ins. That is legitimate as an accommodation request, and that is a trigger to start engaging in an interactive process to determine how you can accommodate that disability. You can request medical documentation for marijuana's need. And so that's not necessarily an ADA rule, but just kind of a general rule. If you're trying to figure out how does this tension between state and federal law work, that's something you can do. And you can also consider an individual's job performance when you're thinking through these various issues. So that is related to and brings us to our last major topic, which is drug testing. And I guess I'll back up and say first, more and more, there are employers who are declining to drug test at all. Fewer of those, but there are many who are declining to drug test for certain substances. And so in some respects, it's sort of a don't ask, don't tell mentality. But particularly for marijuana, this is becoming more and more common because there are certain industries where employers rationalize that, look, if I test for marijuana and I have a zero tolerance workplace and I get a positive test back, I'm going to get positive tests back on 50% of the people that I test for employment for these particular positions. And that may be true based on their past experiences. It may be true based on what they hear from others in their industry. And it may be also just from stereotypes. Like I know X type of worker is often a marijuana user, a pot smoker. Some are just foregoing testing for marijuana at the candidate stage. So they're not doing the pre-employment marijuana testing, or they're limiting the drug panel period that they test for. One thing to always think about when deciding whether to drug test and what it should look like is the Fair Credit Reporting Act. And that is federal law, and it applies to what are called consumer reports. And so typically these are going to be reports that are funneled through a third party, and they are bearing on someone's character. And so that could be their credit, that could be a drug test, that could be looking into their prior employment and background. And so that definition is pretty broad. But the thing is that your drug testing procedure does have to meet the definition of a consumer report, and certain things will and certain things won't. And it's kind of beyond the scope of this presentation to get into that nitty gritty. But if your procedure does meet this criteria, then there are certain disclosures and steps that you would have to follow to meet this law. And so you do have to give certain disclosures before conducting the background check. You have to get the candidate's consent to do it. And then if your drug test or even, background check or other type of report comes back with a positive hit or information that is going to impact your employment decision or the actions you take there and out, you have to give that individual notice before you take an adverse action, a copy of their report showing the source of it, and you have to give them a reasonable time to go and dispute that information. So a key example is you are running a report for Jane Doe or John Doe, very common name. Something might show up on their report that actually isn't them. And so they need time to go back to that agency and say, this needs to be removed. This isn't me. And there's no set amount of time by law that you have to give them, but generally at least 5 business days before you can actually take that adverse action. So you've talked a little bit already about pre-employment testing. And so, this is entirely optional for employers. This is prior to hire. And so that's important when you do give an employment offer. If you intend to do pre-employment testing, you always make it a conditional offer. So that gives you the space and the ability to go conduct background checks and drug testing. Usually it's a urinalysis. And so, pee in a cup. Usually most employers I speak with have a third party conduct this. And the reason is then it's easier to have a medical review officer or MRO who reviews the information and can kind of assess the results. And you use this to reject people from your process if they come back with results that are outside of your criteria. Second type of testing is reasonable suspicion testing. This one is tricky because this is a judgment call, and this goes way back to the start of our presentation when we talked about all the different signs of use or abuse of various different types of drugs or substances. This all comes down to witnessing behaviors or physical characteristics or actions that could indicate a substance impairment or substance abuse. And it really looks at the totality of the circumstances. And you want to keep it objective. So you want to be able to say this person had dilated pupils. They were sweating more than usual. They were a great performer, and now their performance is poor below average all of a sudden. They suddenly have poor attendance. You want to be able to list as many factors as you can that are objective to support your reasonable suspicion. And this is where I think some managers, and totally understandably so, feel either undertrained or uncomfortable making these judgment calls. And that's why it is a good idea, or can be, to have two or more managers, or a manager in human resources, or two qualified trained people with positions of adequate authority making these types of judgment calls. If you have reasonable suspicion, you can then send the employee to do a drug and alcohol test. Post-accident is another common reason that is permissible to do drug or alcohol testing. And so you're really looking at what is the root cause for an accident that happened and who could have been involved in that root cause or who was involved. And that's the universe of people that you want to test. And you don't want to cherry pick and only test some of those people. And in fact, OSHA, the Occupational Safety and Health Administration, has issued standards on this, where you really need to test everyone that could have been involved. Random drug testing, it's often used by employers that have safety-sensitive positions. And so you can set up a program where you are having a random system, pick and choose. Periodically, employee D and employee Y are getting tested today. But always check and make sure, number one, are there regulations requiring us to do random testing? Or number two, are there any regulations limiting the types of random testing we can do? And then the often forgotten reason that you can drug test is rehabilitation. So if you have an employee who goes out on an ADA accommodation because they are a recovering addict and they return to work, you can set up limited parameters for rehabilitation drug testing, just, making sure they're not relapsing, that they're on track. It cannot be punitive, but it has to be within the safety interests of your organization, just to be sure they are, in fact, not using drugs. And it also cannot go on forever and ever and ever. So that is a situation that's very factual as well, where you'd want to consult with counsel on what would be appropriate or reasonable. So with that said, we've talked for an hour about marijuana and other types of drugs and how those impact the workplace. I'm happy to take a couple questions if there are any. I'm also happy to communicate after the program if you'd like to chat about any of these topics. And I hope that this has been educational, informative, and that will help you with either your own workplaces or working with clients on these issues.
Wonderful. Thank you so much, Jackie, for that presentation and sharing your expertise with us today. I'll give you all a moment to note her email down. We'll go ahead and take a few questions. So, our first question, Jackie, comes from Josh. They ask, can't an employer rely on federal law to terminate employees for positive drug tests? Doesn't federal law trump state law?
Thank you for the question, Josh. And I will say, just as a disclaimer, this whole presentation, as well as my answers to questions, they are not giving legal advice. And I cannot and will not do that on this presentation and this platform because we don't have any sort of attorney-client relationship. But yes, so federal law, marijuana, and drugs are still illegal. And so federal law is certainly acceptable to rely upon in terms of terminating them for a positive drug test. The exception is if you're in one of those states we talked about, or one of those states that or localities that enacts the law with anti-discrimination provisions, there may be limits on what you can do under state law. So it is important to check both. And that's where that tension comes in that we talked about.
Thank you for that insight, Jackie. Our next question is, if an employee tests positive for marijuana in their system, how would an employer investigate to find out if they're potentially using on the job?
Sure. So I think, broadly speaking, I think you first look at what are your internal policies in terms of testing and what are the consequences for a positive test and what jurisdiction you're in, because that positive test, that may be enough if you wanted to take the action to terminate or other discipline. That might be your source right there to be able to do that and would eliminate a need for an investigation. But in terms of the test, I think it's also important to think what was the reason for the test in the first place. And so if the test was based upon reasonable suspicion, then you would have already gone into that circumstance having those articulable factors that, things that you have observed or that you've seen. And those could be things like they're coming in with bloodshot eyes all the time, anything up to, somebody reported seeing a blunt or a bong in their purse. And so you may already have those facts, but I guess if you're going into the drug test and it was for a different reason that you were testing, then in terms of investigation, I think you handle that like any other type of employment investigation. And so usually those involve talking to that employee, talking to others, interviewing the appropriate universe of individuals to see who, may have seen things. But I think if you're already at the point of that positive result, depending on the law in that jurisdiction, you may already have enough to proceed and to take some sort of action.
Awesome. Thank you, Jackie. And then I think we have time for one more question, so we'll take this one. This person asks, how can you ensure that upper level management is included in any testing required rather than being excluded? So would you write that in a policy, or what would you recommend for making sure that upper level management was also included?
Yeah, I mean that's the way to do it. You put it in a policy, and I've never written or seen a policy that excludes upper level management as a classification of employee. Um, but assuming there is some sort of maybe cultural reason why upper level management is either typically excluded or maybe testing isn't being applied uniformly, I think it starts with your policy, but then you also have to look at implementation. And so is the company really following what's been put in writing? Because a policy is only as good as how you're actually following it. Um, and if there is an issue with upper level management and someone is abusing drugs, they present the same sort of safety issues and concerns as any other employee would. And so, I think that's why policies really don't tend to exclude them. They might be excluded, for instance, if you have a random drug testing policy that's only focused on certain safety sensitive positions. If the thought is that upper level management, they're in an office setting, they're not moving heavy equipment, they're not doing construction. that sort of thing. But generally, the policies are going to apply across employees. So if it's an implementation issue, I think that's something to take up the chain of command within your organization. And I don't know if that would be something that you would have to take then to a board of directors if it was a very high level executive that was exhibiting these behaviors, or what sort of governance structure you would have. But yeah, I mean, it starts with policy.
Well, thank you so much, Jackie, for taking that extra time to answer our audience questions. And thank you to everyone who submitted questions. We really appreciate your participation. We want to thank you all so much for joining us for another Justia webinar. Before you go, as I mentioned at the top of the presentation, don't forget that upgrading to Justia Connect Pro gives you access to CLE credit opportunities through select live and on-demand webinars, helping you stay informed and meet your CLE requirements. Pro members also enjoy an enhanced directory profile, the AI-powered Justia chat to capture more leads, and discounts on Justia marketing solutions. To take advantage of these benefits or just explore, you can go to pro.justia.com. Thank you all so much for joining, and have a wonderful rest of your day. Thanks for watching. We hope you enjoyed this video, and if you did enjoy it, please click the like button and subscribe to our channel for more videos on law practice and legal marketing. See you in our next video.